It's a Sunday, so it's a car vlog, obviously. That's Barney, obviously. And today we are talking about Sargon of Akkad's copyright victory against Aquila, obviously. And whether or not she's going to have to pay his attorney fees after having her lawsuit thrown out. My prediction, she is going to have to pay Sargon of Akkad's legal fees, obviously. And we're not even 30 seconds into this video, and that joke has gotten old already.
Obviously.
Too many people are asking me to do a vlog on this Sargon of Akkad's copyright victory against a YouTuber named Aquila, obviously. I have been a little reluctant to do a vlog on the subject just because I've done so many videos on copyright. I didn't think there was anything novel in this, and we were just going to be going over the same principles we've gone over in previous vlogs. But alas, there is in fact something novel in this particular lawsuit, in that Sargon of Akkad has now turned around and is claiming his legal fees against Aquila, obviously, after her lawsuit was thrown out. That, and there was one interesting element in the dismissal of Aquila, obviously's lawsuit against Sargon of Akkad, which we'll get into in the summary of the situation prior to getting into Sargon of Akkad's motion to claim legal fees. Who is Sargon of Akkad? He's a famous YouTuber. I'm just going to read his description from Wikipedia, so take that for what it's worth. Carl Benjamin, born 1979, is a British anti-feminist YouTuber with the online pseudonym Sargon of Akkad. A member of the Eurosceptic right-wing UK Independence Party, he was one of its unsuccessful candidates for the South West England constituency in the 2019 European Parliament election. Alright, and who is Aquila, obviously? Again, reading from Wikipedia. Aquila Hughes, born August 31st, 1989, is an American writer, comedian, YouTuber, and podcaster. She is originally from Northern Kentucky and now resides in Los Angeles. She has been a digital correspondent for MTV, HBO, Fusion Comedy Central, and more. She began her career on her YouTube channel, that typo is actually in Wikipedia, which has amassed more than 150,000 subscribers. In October 2019, her daily news podcast, What a Day from Crooked Media, debuted at #1 on the charts. And what gave rise to this lawsuit between Aquila, obviously, and Carl Benjamin, aka Sargon of Akkad? After Hillary Clinton lost the 2016 presidential election, Aquila obviously put out a video called We Thought She Would Win. It was a 9-minute and 51-second video explaining how they thought Hillary Clinton was going to win the presidential election. After Aquila obviously published that video on her YouTube channel, Sargon of Akkad published his own video on his own channel entitled RIV Levels of Awareness. Those letters are actually one letter in front of each actual letter in that first 3-letter acronym. I'm just using that so that YouTube doesn't flag this video and demonetize it. We actually live in an era where I don't know if I say those words on YouTube, if YouTube flags the video and demonetizes it because it doesn't like that type of content. RIV is how I'm going to refer to it from now on. The video that Sargon of Akkad published on his channel entitled RIV Levels of Awareness is a 1-minute and 59-second video, which consists basically of clips from Aquila obviously's 9-minute and 50-second video. There is no verbal commentary or critique, there is no text, it is just edited down portions of Aquila obviously's original video. And what happens? Aquila obviously claims copyright infringement against Carl Benjamin for his use of clips from her original video, We Thought She Would Win. She files a DMCA takedown notice which Carl Benjamin contests, and then she sues Carl Benjamin for copyright infringement. Carl Benjamin filed a DMCA takedown counter notice on the basis that his use of Aquila obviously's content was obviously fair use. It was obviously critique, it was obviously commentary, and it was obviously not copyright infringement. Aquila obviously sued Carl Benjamin for copyright infringement, and Carl Benjamin filed a motion to dismiss under a Rule 12b-6. Alright, and we don't need to get into this in detail because we've talked about Rule 12b-6s in many previous vlogs, but basically a Rule 12b-6 is the dismissal of a lawsuit for failure to state a claim. And if you hear that noise, it's my dog going to town on himself. What are you doing? 3 years after the lawsuit was filed, it was finally dismissed on the basis that the use Carl Benjamin made of Aquila Hughes' content was quintessential fair use. We've talked about copyright, we've talked about fair use in multiple previous vlogs. The one novel aspect of the Carl Benjamin judgment is that the judge came to the conclusion that notwithstanding the absence of any verbal commentary, notwithstanding the absence of any verbal critique, editing in and of itself can constitute quintessential fair use for the purposes of critique or commentary. The judge came to the conclusion that it was in how Carl Benjamin edited Aquila obviously's original content that it became obvious critique. And to the extent that it was obviously critique, it was obviously fair use, quintessential fair use in the words of the judge. So a smashing victory for Sargon of Akkad and a crushing defeat for Aquila obviously. So now what happens? Sargon of Akkad is going after Aquila obviously for his legal fees. And so he, through counsel, just filed a memorandum in which he justifies why he believes that he is entitled to repayment of his legal fees incurred as a result of Aquila obviously's lawsuit. So let's go through that. Please take notice that defendant Carl Benjamin, aka Sargon of Akkad, hereby... What's up? You going to the park?
I'm going to the park. I need Ethan's gloves.
I don't have Ethan's gloves.
They're in the other side.
Where were we? Please take notice that defendant Carl Benjamin, aka Sargon of Akkad, hereby moves for an award of attorney's fees and full costs pursuant to 17 U.S.C. 505 and Federal Rules of Civil Procedure 54D. By this motion, defendant seeks attorney's fees in the amount of $33,419.35 plus actual costs and fees associated with this motion, estimated at approximately $5,000 plus $126.54 in costs. All right, that was just the notice. Now let's get into the actual memorandum. Summary of the case. Plaintiff is a YouTube celebrity. Defendant publicly, quote, singled out and mocked plaintiff, quote, to discredit her and her political positions. Complaint, paragraphs 3 and 42. Plaintiff took offense at that, so she sued Sargon under the Copyright Act. The lawsuit was transparently an attempt to muzzle an ideological opponent for his critical political speech. Even before he appeared in the case, Sargon warned plaintiff that the fair use doctrine barred her claims. He informed plaintiff by letter that if she chose to proceed, defendant would prevail and would seek attorney's fees under the Copyright Act. Plaintiff's counsel withdrew. New counsel appeared for plaintiff at an initial conference. There, the court asked counsel to explain why defendant's work is not, quote, quintessential fair use. And just to state the obvious here, when counsel withdraws from a file, typically it is never a good sign. It means that for any number of reasons, the relationship between client and attorney has gone sour. Attorneys will withdraw from a file if they are not getting paid. They'll withdraw from a file if they're getting unreasonable demands from their client. So the fact that Akilah Obviously's initial counsel withdrew from the file is not a good sign to begin with. And incidentally, good for them, because what invariably happens if an attorney stays in the file and follows the unreasonable demands of their clients, they will get blamed for the results that ensue. I strongly suspect that Akilah Obviously is now looking at her attorneys and saying, how did you get me into this mess? You're the experts. You were supposed to tell me what to do and what not to do. You were not supposed to follow my advice. And so the initial attorneys that withdrew from the file can now look back at this and say, I told you so. Meanwhile, I suspect that Akilah Obviously is going to turn against her current counsel because they got her into a big mess that might end up costing her an additional $40,000. Advice to lawyers and advice to clients. Lawyers give advice that their clients follow. When clients begin dictating the course of conduct to their attorneys are no longer advisors or counsel. Their attorneys are basically there to follow the client's orders, and that gets everyone into trouble. All right, back to the memorandum. The court observed that the, quote, only question presented by the complaint is whether the fair use defense can be decided on a motion to dismiss or whether it would have to wait until summary judgment. And this is a very subtle distinction between a motion to dismiss and a summary judgment. Typically, summary judgments come after depositions, after examinations. A motion to dismiss under a Rule 12b-6 comes before depositions, and it comes on the basis that the lawsuit as drafted fails to state a claim in law. And the response is the typical response by an attorney. They're basically saying, look, we have to examine people in this file. We have to go a little further into this file before we can determine whether or not it's frivolous. Unfortunately, in this case, it didn't get past depositions and it was determined to be frivolous. Apparently undeterred by the court's assessment of her claims, plaintiff then made her first and only settlement offer, demanding that Sargon pay $46,000 to settle a meritless case. Let me just clarify something here. We are reading through Sargon of Akkad's memorandum, so these are all the facts according to him, so take them for what they're worth. These facts are not yet proven facts before the court. But according to Sargon of Akkad, after the court apparently warned Akilah Obviously of the potential frivolity of her lawsuit, her first and only settlement offer was that Sargon of Akkad pay her $46,000 for copyright infringement. And then Sargon of Akkad goes on to explain that to the extent that Akilah Obviously's settlement demand would probably exceed the cost of his defense, he just went on to file the motion to dismiss. And that motion to dismiss was granted with prejudice, meaning that Akilah Obviously cannot amend or refile to remedy the weaknesses in the original complaint, so to speak. Sargon of Akkad then goes on to cite the provisions of law that allow for him to claim legal fees from the failed lawsuit. Section 505 of the Copyright Act provides, in any civil action under this title, the court in its discretion may allow the recovery of full costs by or against any party other than the United States or an officer thereof. The court may also award a reasonable attorney's fee to the prevailing party as part of the costs. When exercising discretion to award fees, courts give, quote, substantial weight to the, quote, objective reasonableness of the losing party's position, while taking into account, quote, all other circumstances relevant to granting fees. Relevant circumstances include the losing party's, quote, motivation, as well as the, quote, need in particular circumstances to advance considerations of compensation and deterrence. And this criteria of motivation is going to come back to bite Akilah Obviously in the butt. Obviously. And we'll get into this in a bit, but in the context of her lawsuit against Sargon of Akkad, Akilah Obviously took to Twitter and made her intentions known. She tweeted things that could not be untweeted that the court will undoubtedly take into consideration in granting Sargon of Akkad's motion. And then we discussed the criteria of imposing legal fees to further the interests of the Copyright Act. Simply put, quote, the touchstone of Section 505 is whether imposition of attorney's fees will further the interests of the Copyright Act, not only to deter infringement, but also to ensure that the boundaries of copyright law are demarcated demarcated as clearly as possible in order to maximize the public exposure to valuable works. The Copyright Act, quote, serves the purpose of enriching the general public through access to creative works. To this end, copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by a work. The copyright statute itself enshrines, quote, criticism and, quote, comment as non-infringing fair use. Transformative works like defendant's critical video enrich the public and therefore, quote, lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright. And here it might be useful just to touch on some of the considerations in the dismissal of Akiva Obviously's lawsuit. In that judgment, the judge clearly and unequivocally stated that what Sargon of Akkad did with Akiva Obviously's content qualified as critique. The judge rightly noted that there was no real risk of Sargon of Akkad usurping the market share from Akiva Obviously because the target market for Sargon of Akkad was totally different than the market for Akiva Obviously. The judge also rightly noted that by Akiva Obviously's own admission, the use made by Sargon of Akkad demeaned or insulted Akiva Obviously. That is the diametric opposite to copyright infringement. The purpose of the Copyright Act was never to protect individuals from ridicule, it was to protect them from unauthorized reproduction of their original work. That being said, the unauthorized reproduction of someone else's copyrighted work would not be demeaning or insulting unless there was something transformative in it. And so by the mere fact that Akiva Obviously admitted that Sargon of Akkad's video demeaned her was proof of its transformative value. And it evidenced the fact that Akiva Obviously was basically abusing of the Copyright Act to silence ideological adversaries. And now Sargon of Akkad is arguing that in order to further the protections and principles of the Copyright Act, Akiva should be ordered to pay Sargon of Akkad's legal fees so as to deter people from abusing of the Copyright Act to silence their critics. It's a wonderful argument that reads perfectly with the judgment dismissing Akiva Obviously's complaint. And then later on, Sargon of Akkad argues that Akiva Obviously litigated her lawsuit unreasonably. Section B, plaintiff litigated her claims unreasonably. Tilting further, a fee award is warranted because plaintiff made no reasonable effort to settle or dismiss her meritless claims. A losing party's, quote, lack of any reasonable attempt to resolve a litigation is relevant to the, quote, need in particular circumstances to advance considerations of compensation and deterrence. Now, something interesting that's going to drive some people crazy that I've mentioned in previous vlogs, in Quebec, very rarely does a losing party pay the legal fees of the winning party. In order to obtain recovery of your legal fees, the lawsuit or the motion or the procedure has to be patently abusive. That being said, in federal court or under copyright claims, typically the losing party pays. And in federal court and copyright claims, you have what are called with prejudice settlement offers, meaning that a party makes a settlement offer with prejudice in that if the final judgment is at least as favorable as was that settlement offer, they will then claim their legal fees incurred as a result of the refusal to accept that settlement offer. Now, I have tried on numerous occasions to import this principle into the Quebec civil law system. I have made multiple with prejudice settlement offers that I have then tried to submit to the judge, but typically the judges just say, no, I don't want to know anything about your settlement offers, keep them out of court. I think it's very unfair. It does not deter, let's just call it unjudicious use of the court systems, and it doesn't punish a losing party enough for having taken what might not be patently abusive proceedings, but what might have been frivolous proceedings or highly unlikely to be successful proceedings. And now we get to the tweets, which are obviously going to come back to haunt Akiva Obviously. Plaintiff's motivations are contrary to the purposes of the Copyright Act. Quote, a party is improperly motivated where it asserts claims not because of their inherent merit, but rather because the party seeks to knowingly gamble on an unreasonable legal theory in order to achieve a secondary gain. After filing the lawsuit, plaintiff pressed on with her censorious attack. She tweeted to her more than 100,000 Twitter followers that, quote, this carnival barker that I'm suing for copyright infringement just got banned from Patreon. Do you think we can get GoFundMe to drop him? The request unmistakably incites plaintiff's fan base to swarm defendant off the fundraising platforms where he appealed for donations to defray costs of legal defense. As part of the same tactics, plaintiff later publicly suggested on Twitter that she had, quote, reported defendant's, quote, hate content to Patreon in an attempt to have Sargon banned. Plaintiff used this lawsuit as part of a campaign to silence criticism, precisely because it, quote, discredited plaintiff and her political positions. She then openly attempted to bar defendant from raising funds necessary to his own legal defense. Her motivation stands opposite to the Copyright Act's goal of ensuring public access to critical works. That merits fees. And I tend to agree, and I am predicting that Sargon of Akkad is going to get all of the legal fees he's claiming. It also highlights something very important I've mentioned in multiple previous vlogs. Do not take your litigation battles to Twitter. Do not take your litigation battles to social media, period. More likely than not, this all would have had a much different outcome had Akiva Obviously not taken to Twitter to make her intentions clearly known to the world. She might have still lost, but the judgment would not have been as scathing as it was. She might have still lost, but she would have not given fodder to Sargon of Akkad to claim legal fees from her. It may feel good in the moment, but it is going to cause problems in the long run. And included in the memorandum is a screenshot of a tweet that I'm sure Akiva Obviously is going to regret.
obviously.
In his GoFundMe, he lists that the funds are for a, quote, frivolous lawsuit brought on by Akilah Hughes. Seeing as I'm about to win this case, can I sue to get that money since it would be libel? Asking for let's bankrupt this blank. Just to finish by reading a few more sections of the memorandum that I think are particularly relevant. Her only settlement demand of $46,000 strained the boundaries of good faith. Even if plaintiff had established infringement, she would be entitled only to minimal damages. As the court found here, quote, there is no danger that RIV levels of awareness will usurp the market of progressive commentaries such as we thought she would win. Because, quote, Benjamin's target audience is obviously not the same as Hughes' target audience. Moreover, setting aside the other factors that make her claims patently meritless, there was no basis for plaintiff to demand statutory damages, since she did not register copyright until after defendant engaged in the transformative conduct described in the complaint. Plaintiff's unjustified and unreasonable settlement conduct is of a piece with her public threats to, quote, take hundreds of thousands of dollars and to, quote, bankrupt the defendant through litigation. In the face of those tactics, defendant was encouraged to, quote, stand on his rights by, quote, the likelihood that he will recover fees from the opposing party. Awarding fees serves the ends of compensation and deterrence. And in the end, we see that Sargon of Akkad is claiming $33,000 in legal fees plus $5,000 for the motion to claim the legal fees. And for any of you who might be saying that that amount sounds somewhat excessive, let me tell you that $33,000 for what was done in this file over the course of 3 years sounds more than reasonable. It may sound a little absurd to say, but these legal fees could have easily been over $100,000. And although we will probably never know, I would love to know what Akilah Hughes paid her attorneys. And I guarantee you that we are never going to know this, but if her second attorneys were sort of encouraging her to pursue this lawsuit on the basis that she would then get her legal fees paid for Sargon of Akkad, who would lose the suit, I smell a complaint to the bar and fast. But the amount being sought is on its face totally reasonable and probably cheaper than most people would have ever thought. That is where the lawsuit stands as of today, and my prediction is that Sargon of Akkad is going to succeed on his motion to claim legal fees. Hindsight is always 20/20, but I think Akilah obviously is now going to look back at her first attorneys withdrawing from the file and maybe think that she should have followed their advice prior to them withdrawing from the file. Because I am taking for granted that they withdrew from the file because Akilah obviously was refusing to follow their advice. I hope you got something out of this, and if you like my content, please be sure to like, share, subscribe, hit the notification bell so you get reminded when I post a new video. Drop a comment in the comment section below, it feeds the algorithm. Merch links, support links in the pinned comment below, and I'm probably going to be reopening my Patreon account, so stay tuned for a notification to that effect. And now you know your vlog. Peace out. Booyah.